SJC-13558, George Mackie versus Robert Joss, and SJC-13554, George Mackie versus Katrin Rouse-Weir.
Okay, Mr. Mackie, you're up first.
Please the court. My name is George Mackie, and I'm a pro se litigant in both cases. I am here to say that neither Dr. Joss nor Dr. Rouse-Weir should be entitled to any type of immunity whatsoever. There were violations of the statute and common law based on the contents of both reports. And the statute does not specifically state that they're entitled to immunity. And whereas the qualified examiner is only qualified through the Department of Corrections, which is an executive entity, crossing over into the judicial, I believe, violates Rule 30, due to the fact that the only way a qualified examiner can be qualified is through the Department of Corrections. In the case of Dr. Rouse-Weir, she was hired by the Worcester County District Attorney. Now, that particular portion of the statute is not a requirement for determination of SDP. That is based on the fact of the district attorney wanting to look at that issue. As far as Dr. Joss, his immunity should not be allowed based on the fact that, again, he is only qualified through the Department of Corrections. Both reports, again, make inferences to non-convictions, which is the reason I'm able to speak to you here today, because the decision as SDP was overturned by the appeals court. The DA could have hired any psychologist to present information. They did not. They chose to hire a qualified examiner, qualified through the Department of Corrections. The qualified examiners also serve as on the CAB board for the Department of Corrections, which is outside the realm of any judicial inference, allegedly. So therefore, another conflict.
So if the qualified examiner doesn't find the person sexually dangerous, the case ends.
Correct.
So they have a sort of a finality role as well in the judicial process. It's quite unusual.
Yes. However, as in my case with Dr. Joss, after the appeals court overturned the decision of SDP based on use of non-convictions, the next two QEs that I interviewed with found me not sexually dangerous based on the appeals court's decision as far as what can and can't be in these reports. Dr. Joss has also made other errors in other cases, as I stated in the brief. Dr. Rouse-Weir removed 27 paragraphs of information after an interview. Now, in the defendant's brief, they claim that, Dr. Rouse-Weir was acting on behalf of the court as an expert witness and based her information on, I don't want to say an interview, based her information on an investigation. However, that investigation does not include an interview. It's all done through documents. On the advice of my counsel, I did meet with her, and that's when those 27 paragraphs were removed.
So I have a question about that.
Okay.
So she removes the 27 paragraphs, but still concludes the same conclusion.
Correct.
How then, I guess I'm wondering, what your claim is as
She
to the
said-
27 paragraphs, like that, that she misstated, but how did that affect you? The
Well,
removal of the 27 paragraphs?
I believe that she saw that as possible, what's the word I'm looking for?
Exculpatory?
Exculpatory evidence. So if she removed it, she didn't have to testify to it because she said on the stand that she never saw it. However, if it was there in the second report, my attorney could have questioned her on, well, isn't it true that this didn't happen? Or how do you think this could happen? And again, it's all based on information that I was never convicted of. And in Redgate, and I don't have the address in front of me, it does say qualified examiners cannot use information that you were not convicted of. And both of these, Dr. Rouse-Weir and Dr. Joss, based their decisions on that kind of information. Whereas the two qualified examiners that found me not sexually dangerous based their decision on, the fact that I was never convicted of those. I do have some other notes here as far as in Dr. Rouse-Weir's information. The argument by the defendants that I did not provide information in my original complaint that allowed the judge to dismiss under Rule 12b-6. I believe there was sufficient evidence, especially in the removal of 27 paragraphs and other information as far as what she did and did not do. I did present facts in evidence form to prove those allegations that I made. I already said that. Okay, there's a thing on page 27 of the Rouse-Weir brief that states, although a psychiatrist in Milan was appointed by the probation department and not the DOC, the appeals court erred in both Mackie. However, the probation department does not qualify people who are allowed to testify at SDP cases. They do not the probation department doesn't pick, they pick the psychologist, but not from a small group of individuals who are qualified by the Department of Corrections. And in the case of Dr. Joss, where they say on page 23 that the courts allow in Chapman explicitly recognize that QE serve as though appointed by the court. the statute is interpreted way too overbroad in that situation. Because nowhere in the statute does it say any of them are appointed by the court. I'm sorry, please just trying to get through all my notes here. Okay. Both decisions by Rouse-Weir and Dr. Joss are in conflict with the diagnosis of a pedophilic disorder and violated my right to liberty and due process. Therefore, if any immunity was entitled, it would be abandoned due to the constitutional violation. And that also, that's if any immunity, you decide any immunity. I mean, in the case of Annie Dukin and Farouk and I believe the district attorney, all of their immunity was wiped out because of the violation of the statute in the drug cases. And I think there was an issue raised by the appeals court that I believe I found a case that said that there was, if it's a criminal case or a civil case, and there's nothing to cover one or the other, the general principle is that the common law would decide, it would be equal. In other words, the civil law would cover the criminal law would cover the civil law. And I believe I put that in my brief. I don't know if this is a correct time to do this or not, but I would like to object to the presentation of the Department of Corrections amicus brief based on the fact that it parallels the defendant's brief of itself. There are similar case laws used to make certain arguments in both issues. And in saying that, I would also like to object to her testimony here today. Okay, I don't know if I have to do that in writing or I can do it before or after, how that works, but I'd like to make that known. Are there any questions?
I think we're all set.
All set?
All set. Thank you.
Okay, thank you.
Okay, Attorney Walton.
Thank you. May it please the court, my name is Ken Walton, and together with my partner Patricia Gary, we represent Dr. Robert Joss, Dr. Katrin Rouse-Weir. And initially, Your Honors, I'd like to point out that we have agreed to split our time with Attorney Mary Murray of the Department of Corrections. So if it's okay with the court, I'll stop at the 10-minute mark and answer any questions and then turn it over to Attorney Murray. As set forth in the brief, I think there are numerous independent grounds supporting the Superior Court's dismissal of the lawsuits against both Dr. Joss and Dr. Rouse-Weir, both of whom who have performed the important function of a qualified examiner in the Commonwealth. Dr. Joss for over 30 years, Dr. Rouse-Weir for over 25 years. Initially, I'll start with the Rule 12b-9 standard, which this court has articulated in the Lanier case and the Sachs case, and then, of course, the Inchinino case by the Supreme Court of the United States. Every plaintiff, whether they are represented or pro se, has the obligation to set forth a clear statement of their case with, to quote, plausibly suggesting an entitlement to relief.
So the issue in this case is this kind of hybrid model, because clearly they're paid for by the DOC, and similar to that of an expert witness hired by the government in, say, a NGI, a criminal responsibility case. But they are also statutorily appointed or mandated, and you can't get a SDP case without 2 QEs. You need at least one. So where does that fit, the role of the QE, given the payment structure and the statutory role of a QE?
Thank you, Your Honor. So on that question, in this case, to be clear, Dr. Joss was a QE. That was his job. Dr. Rouse-Weir was hired by the district attorney's office to assist with the probable cause procedure or hearing that precedes the actual formal hearing. But I think it's important, and this court articulated it in the Bruno case, that both of those roles are statutorily required. Now, is the district attorney's retention of an expert articulated explicitly in the statute? No, it's not. However, it is a necessary element for the district attorney to be able to get over the probable cause standard. They need that expert witness. So the Bruno case was very clear on that point, in my opinion, on saying that you need both of these things for the district attorney to get through the probable cause finding.
But the difference between the two is that the QE, regardless of the outcome of their investigation and whether they conclude that the person is an SDP or not, must submit that report to the court. Whereas the probable cause expert, the DA can keep hiring whoever they want to until they get somebody who will say, yeah, there's this person's an SDP.
That's very true.
So that makes them different in kind to me. So the QE seems more like a court-appointed expert because you, the DA, don't control whether that report comes to the court or not.
I think that distinction is true. However, the immunities that provide expert witnesses immunity, not only in this context, but in really any civil case or criminal case. Because if you have a case going to trial on the civil level or the criminal level, you're going to have 2 experts. They are going to have 2 different opinions. That's just the nature of the beast. So if the new standard is that you can sue an expert because you don't like their opinion, because you don't agree with their opinion, then the floodgates will open. Because in
So are
every
you arguing litigation privilege?
I have multiple arguments, starting with the qualified. I would argue, Your Honor, to start with the qualified judicial immunity that they are entitled to, because they.
Why is the probable cause expert entitled to quasi-judicial immunity?
Because and this actually rolls into the prosecutorial immunity, which is also argued in the brief, because they are serving as an arm of the prosecutor.
Okay, so not quasi-judicial, but prosecutorial immunity.
Yes,
Okay.
yes.
So Dr. Rouse-Weir might be entitled to prosecutorial immunity. How do you get around the Kalina case?
Well, the Kalina case is all about whether the witness is a complaining witness. That's the standard. And what happened in that case, the district attorney filed filed an affidavit, basically with factual allegations, that the court said, this isn't even necessary for this filing by a district attorney. It's unusual for the district attorney to file this type of affidavit with factual statements. So really, he took himself out of the role of a district attorney and became...
Was it, just to clarify, because you were more familiar with this than I am, but I thought Kalina was about the necessity of the prosecutor being the signatory to the affidavit, not whether or not the affidavit was required at all. It seemed like there needed to be an affidavit, right?
Correct.
Okay, so it was the role of the prosecutor as the signatory to the affidavit that was problematic.
That's correct, Your Honor.
And so why isn't that more like Rouse-Weir?
Because in Rouse-Weir, as I mentioned, the Bruno case requires experts for these two roles. The DA needs an expert or they don't get by the probable cause hearing. It's a necessary prosecutorial function.
Do you separate the prosecutorial function by whether or not there's a court role versus an investigative role? For one, if you act like a cop, you get sued like a cop. That's how I was always told.
Yes.
And cops only get qualified.
Right, because they're investigatory.
And, Your Honor, I apologize if I missed your question.
No, so the question is, when we look at Rouse-Weir under prosecutorial immunity, isn't the issue whether or not she's fulfilling a court role? She's testifying in a probable cause hearing, right?
Well, I think that the standard for prosecutorial immunity, or the best case on that particular issue, is the CM case by this court, excuse me, where the court held that absolute prosecutorial immunity protects the social worker initiating a care and protection proceeding. And that case is almost identical procedurally. I mean, it's you change the names, and obviously this involves doctors and that involves the social worker, but it's right on point. And
But Rouse-Weir didn't initiate this proceeding. She was an expert on behalf of the Commonwealth that initiated the proceeding.
I agree, but her role, the proceeding never could have gotten to where it got to.
Yeah, the Commonwealth couldn't meet its burden of proof without her.
Right, which wraps
And
her.
so any evidence submitted to meet the burden of proof is immune under prosecutorial immunity?
If it's done in good faith, I mean, an
But
expert.
he alleges it was malicious,
Well,
not in good faith.
But what I would say to that is there are no allegations to support that. If you're going to make an allegation against somebody, a professional, and say you did something malicious or intentional wrong, then you have to come up with more in your complaint or somewhere to support those allegations. And saying that Dr. Rouse-Weir, because she says she didn't, but I'll accept that as true for here, because that's the Rule 12b-9 standard. If she deleted 27 pages, that's what we all write expert reports, or experts write expert reports. Sometimes they add information, sometimes they take information away. I'm sure your honors write opinions where you add parts and you take parts away. There's got to be more to rise to the level of allegedly bad conduct by a professional than what's alleged
So I
in
was
this
a little
in this
confused by
case.
that, because I thought you were arguing absolute immunity, which doesn't matter. If it was good faith, bad faith, maliciously, intentionally, it doesn't matter. Now it sounds like you're moved to qualified immunity, in which
No.
those kind of things do matter.
Well, what I was getting to is that, in my view, all of these immunities, not every single immunity that exists, but the ones that we've talked about in our brief, they are all independent grounds. So the court may not agree with me on one of the immunities, but there's another immunity exists. So that was the next argument I was going to make, which is absolute immunity. In this court, in the Schreiber case, I wrote this quote down exactly because I think it applies exactly, held that statements made by a party, counsel, or witness in the institution of or during the course of a judicial proceeding are absolutely privileged and protected, provided such statements relate to that proceeding.
Yeah, that was my question to you initially, which is why, are you arguing litigation privilege, which is what that Schreiber case is all about? It sounds like, yes, you are.
Yes.
And was that an argument that you raised below?
We did not raise that below.
Given that posture, what do we do?
Well, I think the Gabidian case, also by this court, says that it is well established that on appeal, the SJC may consider any ground apparent on the record that supports the result reached in the lower court. That's the case I would cite to. And so the lower court got it right. They reached the right result. They did not address, and perhaps counsel did not address, every single immunity that is now discussed in our brief. But, and you know, that's obviously a very legitimate question, but I think the Gabidian case saves it. And I would conclude, just because I don't want to cut off Attorney Murray, that I do believe all of these immunities that are discussed in our brief and the 12B9 standard provide independent bases to support the lower court's decision. Before I sit down, are there any more questions from me, Your Honors?
I don't think so.
Thank you.
And Mr. Mackie, I think you were asking, your motion was for Attorney Murray not to testify. Okay, so I'm going to deny that motion, and she's gonna.
Good morning, and may it please the court. Mary Murray for Amicus Department of Correction. Thank you for extending the invitation on our motion to be permitted to argue. 2 grounds in the Joss case support affirming the Superior Court. First, I'll pick up with the litigation privilege. The litigation privilege applies regardless of malice, bad faith, or nefarious motive, according to the Besicious decision cited in the department's papers, 490 Mass at 150. Judge Donatelli in the Superior Court, in her opinion, appears at page 53 of Amicus brief, in footnote 4, indicates that it appears Dr. Joss's statements in the SDP probable cause hearing and jury trial are protected by the litigation privilege. So she, Judge Donatelli herself, raised that issue. The litigation privilege, of course, protects all of the witnesses, lay witnesses, expert witnesses, the parties, and counsel. Otherwise, where would it end? If Dr. Joss and Dr. Rouse-Weir are unhappy with the outcome of, if they prevail, can they turn and sue Mr. Mackie for defamation? If there's no litigation privilege, what would stop them? And then somebody's unhappy with that, and we have more litigation about litigation. And there's no need for that here, because Chapter 123A's own robust procedures protect against wrongful, incorrect commitments. As detailed in Amicus's brief, there are the right to counsel, the right to receive the reports. And indeed, you heard in the earlier arguments with respect to Dr. Rouse-Weir that there were 27 paragraphs missing. The way that that's known is because both reports were turned over. Otherwise, you wouldn't know that there were this allegation about that. The reports are made available, particularly the QE reports by statute are completed within 45 days of the finding of probable cause. They're filed with their court, they're made available. The individual has the right to call his own experts, to cross-examine, to appeal, to have process issued, to secure witnesses, and funds for lawyers and experts if indigent. Robust procedures. Turning to the question of quasi-judicial immunity, this court said in Johnstone, within Chapter 123A's statutory scheme, the qualified examiners are, and I quote, established as independent, court-appointed experts. A few paragraphs later, this court pointed out that QEs are the only experts appointed by the court under Chapter 123A. And the question of who pays them is immaterial, because in Lalonde, where the psychiatrist performing the probate court evaluation of family members relative to a visiting scheduling issue was paid by the father, one of the parties. The Department of Correction is not a party in an SDP proceeding. The Commonwealth is the party. I know that it sometimes confuses people because department attorneys have been asked by the Attorney General to represent the Commonwealth, and the Attorney General, of course, has the authority to make such a designation under her statutory right and authority. But the department is not. The department only has the right to file a petition, and when that petition is filed, if the department thinks it's appropriate, the court still has to appoint QEs and order their evaluations. And the QEs conduct their evaluations only in the context of a pending proceeding under court order. The statute in Chapter In the initial commitment cases, once probable cause is found, the court shall order evaluation by 2 QEs. When a Section 9 petition is filed, the court shall order evaluation by QEs. And there are other protections. The qualified examiners have to follow.
So Rouse-Weir is entitled to litigation privilege.
Absolutely.
And Joss is entitled to quasi-judicial.
Yes, and litigation privilege. And there may
Right.
be some other privileges, but those were the ones the court invited amicus to address, and that's what we addressed in the Joss case. Absolutely. Given the consistency and longevity of this court saying that the QEs conduct court-appointed evaluations, Sheridan, 1992, Connors, 2006, Sargent, 2007, Johnstone, 2009, Ganji, 2012, this court said that the QEs are court-appointed experts, but the Commonwealth must make sure that the treatment center gets the reports done on time. And impose that burden on the Commonwealth to keep the case moving forward, which is reasonable enough. It's the Commonwealth's petition. Chapman and Green.
I think if anybody, we're all set.